Hey, what's up, guys? It's your host, Fuquan Bilal here, PFREI, a passion for real estate investing. And today I'm here with attorneys, Sean Mills and Brian Goldberg from O'Kelly and Sorohan. We're going to talk a little bit today about foreclosure in real estate. These guys actually handle a lot of note sellers and buyers. They do a lot of foreclosure work in the states. What is it? Georgia and Florida, right?
Correct.
Okay, and a couple other states you guys do too as well, right?
Just Georgia and Florida. We have a sister title company that called OS National that is able to do title and escrow work in every state.
Okay, awesome. So whether you're a real estate investor or a note investor, I would definitely advise you guys to get with them and kind of pick their brains on legal strategies that you can use to recover, if you're doing some collections in that state, or if you need some legal action in that state. So we'll start with you, Brian. Just kind of talk about the specialty that service that your firm handles.
Sure. Yeah, so I'm Brian Goldberg, and I'm in the Georgia office in Duluth, Georgia. I practice only in Georgia, and I do foreclosure, title litigation, bankruptcy, pretty much anything that has to do with real estate and litigation involving that in the state. We have, we do contract work, reviewing contracts, and just answering general questions about the note industry. And we've been working in this area for quite a many years. We worked with you quite a bit, and a lot of people that are here at the conference. So.
Yeah, that was cool. I remember the first case that I brought to you. It turned into a REO. And then the borrower actually reinstated. They brought the check to your office and everything. And I was like, wow, that was the first file that I had that we foreclosed on in Georgia. And the borrower actually came in and reinstated. So it was a good thing. We were able to keep the borrower in the house. They did a good job handling the foreclosure. I remember the big bill, but it was worth it. Definitely worth it. So now you handle Florida.
Correct.
And you do all of Florida. Florida is actually interesting because for a while, when the market went down in 2008, nobody wanted to touch Florida. Now you see everybody's back in, a lot of the foreigners in, making things happen. A lot of people are buying notes.
Correct. And
you're seeing some of that stuff where you're able to assist with, recovering on those assets. So talk a little bit about Florida. If you want to jump into statute of limitations or whatever, because that's, to me, a homestead friendly.
Yep. So Florida. So I manage our Florida operations out of Orlando. We're centrally located, so we cover the entire state. The biggest state right now is probably down in South Florida. You're seeing a lot in Broward, Palm Beach, Miami-Dade. Those are probably the hardest hit areas during the recession. So you're seeing still a lot of foreclosures down there. A lot of secondary notes on the market. So we're busy. It's good. Biggest difference, I guess, with Florida and Georgia is Georgia's non-judicial, and Florida we are judicial. So it takes a little bit longer, but don't believe all the stories out there about how terrible it is there. We still push them through pretty quickly. But yeah, as far as I guess probably the biggest thing that we've in Florida over the last couple of years, the case law has become very well settled, which is good for plaintiffs' counsel and for investors. So we're not having all these crazy arguments that are being thrown out by defense attorneys. The law is pretty settled. Biggest issue that just got recently settled by the Supreme Court is the statute of limitations. So we're able to work with our clients, even if it's on a non-performing loan where the borrower has been defaulted well past the 5-year statute of limitations. We're able to bump up the default date, get them within the 5 years, and there's even some counsel that are going after stuff from past the 5 years. You'll see how that plays out, but it's creating an opportunity for investors to come in and take some of these really old notes and still be able to collect on them and foreclose. So.
Yeah, when we were facing that, we would just, because as you know, when you do buy notes, seconds, primarily you buy off a percentage of the unpaid balance. And first you buy off a percentage of the BPO, which sometimes in most cases is less than half of whatever the UPB is. But some investors want to go after the arrears and everything else when they purchase off of just the UPB. So what we just do is just try to collect off the principal balance just to make it easier. And if there's some arrears that we can collect, to reset the borrower, we do that. Statute of limitations have really been a big shift in the market that we've seen pushback. But now let's talk a little bit about pay history. That's something else that we've seen shift the market. when people are asking for pay history, and unless the purchaser bought it direct from the bank, it's kind of tough sometimes for that pay history to flow down from the custodian or whatever from the prior seller. What are some of the challenges that you see in the market when it's being contested and they're asking for pay history? I know there's some strategy to use. It can be an affidavit or certain things to get around that.
Correct.
What are you guys seeing?
Well, I mean, for us, mostly, I think it comes up a lot in the bankruptcy context because we have to file proof of claims. And the proof of claim the new form that they came out with most recently requires actually payment history to be attached as an exhibit on the proof of claim itself. So when we get to that point, it gets very difficult if you run into those issues where you're not able to acquire them. So a lot of times, we are having to go back and basically trying to help our client calculate how, the unpaid principal balance gets to this point using amortization schedules and just using the evidence that we have. Proof of payments obviously help to show what was paid, when it was paid, and a lot of times, the borrower's not going to have it. So, due diligence as much as possible, calling as many people as possible down the custody chain to find out who had it last, when was the last time they saw it, if they can get it. Sometimes you never know. Phone call can help.
Yeah. Do you guys subpoena also up the chain to the original lender or somewhere like that?
You can if needed. I think one of the biggest things is knowing who you're buying your notes from, knowing not only who you're buying your notes from, but who they use as a servicer, because you're going to be able to know what type of servicing records that they do have. That definitely helps. I mean, there's ways around it. If it comes down to it, there's also discovery that you can do. We always talk about defendants propounding discovery on plaintiffs, but discovery works both ways. So, if it's a document that you don't have and you ask them to produce, you can ask the defendant to produce that as well. Do requests for admissions against them as well. So if they're not able to produce that evidence either, then neither one of you can at trial. So there's certain strategies as well. So it's not always a one-way street when it comes to that information, but it's definitely something that I encourage clients to look at as far as in their due diligence stage. You want to know that you have the note, the mortgage, all the allonges, all the originals, the complete chain of assignments and everything. But go that extra step and look at the payment history and know exactly when the last default date or last payment date was. If they have any proof of payments, was it all done electronically? Were they sending them in via check, etc.? Did the payments change because of a loan modification? Are you getting that document from the person you're purchasing it from? So it really starts at the beginning when you're looking at purchasing the note and making sure that it's an important piece in your package that you want to get from whoever you're purchasing from.
Yeah, definitely, because most sellers will only give you the note, mortgage assignment, allonges with the file, and it's rare that you get paid history again unless you buy direct. So that's good that there are workarounds, there are certain strategies that can be done in order to move the file forward. I mean, our whole goal is to really work something out. Our model is if we foreclose, we fail, especially if it's a second mortgage. We don't really want to take the property, we just want to get the payment. I know that you guys work with a lot of note investors and a lot of real estate investors. I know you see so many different things come across the desk. So that's great that there are strategies and workarounds you can implement. What are you seeing in Georgia as far as foreclosure? Are you seeing it, the percentage is lower now versus before? Is it slower?
Yeah.
As far as more foreclosures pushing through, what are you seeing in Georgia?
So I think the foreclosures have kind of steadied. They've evened out. They've definitely decreased from the height in the Great Recession, but they have kind of steadied out and become more. We've reached, I think, a baseline of the foreclosures. The thing that the latest trend actually is a good one, and I think we've been very successful in working a lot more of the potential foreclosures out. We've had a lot more success in doing workouts, loan modifications. I think a lot more people are working now, so they have the income. So recently, that's the trend I've noticed is we are moving forward. We want to keep the borrowers in their house. You're not in the business of owning property as a lender or as an investor, and we communicate that with the borrowers so that they try and to understand that we're trying to be flexible and work with them, and it's been working. So it's good. It's a very good thing.
Well, I know New Jersey is now the number one foreclosure state. At one time, Florida was a little past us. Where is Florida now in the foreclosure?
We're happy to give off that.
There's some more properties available. So.
Florida's also kind of leveled off. The filings are definitely down from what they were before. We also work with first note investors as well. And on those, you definitely see that there's an outreach to the borrowers, sometimes of 15 to 20 times before it even gets to our office. So there's a lot of outreach that's being done so it doesn't have to go to foreclosure. Foreclosure is usually, is obviously the last resort for the most part. But we're definitely seeing a lot of seconds, but we're seeing, seconds where people just ignore them for a long time. And our clients are being aggressive, but they're also being aggressive, going forward with foreclosure, but being aggressive as far as settlement's concerned. And that's what we try to do for them as well, because at the end of the day, it's, foreclosures, it's pretty much a simple breach of contract case that's got a few regulations involved in it. And for the most part, these people, there's not much as far as defenses. They didn't pay their mortgage. And so we're at a situation where if they're actually represented by counsel who knows what they're doing, we got to figure out a situation. Either, we're going to go forward with the foreclosure and they're going to ask for a certain amount of time, or we're going to work something out. And for the most part, we're seeing a lot of people willing to work something out, knowing that, this debt just isn't going away.
That's awesome. Now, foreclosure versus suing in a note. Are you seeing your clients use both strategies? I know it's more foreclosure than suing. We use the strategy of suing in judicial states because it's faster. We can get a judgment against other assets. Mm-hmm. What are you seeing in Georgia? Are investors using that strategy?
Occasionally, it just depends on the situation. But if the lender or investor knows that the borrower has other assets, then they're usually suing on the note first. Because Georgia's a non-judicial foreclosure state, a lot of times it doesn't make sense because you're going to be spending a whole lot more time on suing on the note than you would in the foreclosure process. And sometimes it's just not worth it to spend that time. We're able to foreclose, in probably 45 days or so from the time that we send the notice of foreclosure to that next Tuesday of the month that the foreclosure is being held. Mm-hmm. So a lawsuit is going to take 6 months to a year. So people definitely are really considering whether or not that's worth it ahead of time and looking into doing their due diligence to see if they have any assets first.
But let me ask you on the suing in a note part, and I heard a mix from different attorneys. So I have a collateral file, I'm missing an assignment, but I have the note and I have the allonge. Mm-hmm. The note is the instrument that I'm suing on, and I have the chain that the note is endorsed to me. If I don't have that assignment, can I still sue on the note in Georgia because I have the note and the allonge? I don't have the assignment though.
Yeah, there is actually a line of cases that I just had a case about this in bankruptcy court. There's a line of cases in Georgia that says that the assignment follows the note and vice versa. So although they are two separate instruments, they follow each other when one is transferred.
So what if the foreclosure on the first wipes out the second? The borrower didn't file bankruptcy, but I still have that note and those allonges, but now the assignment is no longer valid because it was foreclosed on. That secured part went away, so now I just have the note and the allonge. What about in that case? Do I still need to have it all together?
Well, if you have a second and the first has been foreclosed, that wipes out the secured portion of it. So you no longer have any sort of attachment of the collateral from that instrument, the promissory note. So now it's basically just out there. It's unsecured. There's no collateral that it's attached to. So suing on the note at that point would probably be the good strategy because especially if they have other assets, your goal is to get a judgment so that it attaches to anything else that they have. And a judgment will be an attachment to any personal property that they have in the entire state or any real estate that they have in the county where the judgment was entered. and then we take that judgment, we record it in any other county that they have any other real estate in it, and it would attach to those.
Awesome. What about in Florida? Is it the same, different?
Yeah, that's really kind of your only real option at that point if you have been foreclosed out by the first. The mortgage is wiped out as far as the lien is concerned, so you're suing on the note. Hopefully the person has to file for bankruptcy, and then you're going to get a judgment against them individually. Same thing to where you can then go after assets that they have within the state. You can even have it domesticated in another state if they have assets there as well. But yeah, that's what you got to do as far as that's concerned. And what you were talking about also with the chain of assignments. Same thing for Florida. For us, the most important document is the note. And as long as the note is complete with a full chain of allonges or endorsements, then you're good to go. So even if you don't have an assignment of mortgage, or even if the assignment of mortgage is faulty and is incorrect, in Florida, the mortgage follows the note. So there's no need for an assignment of mortgage to even be there. It's more out there to be recorded in the public records for notice provisions.
Awesome. So we can basically say it's state by state, whereas if you can sue on a note that doesn't have an allonge in Georgia, you said the mortgage follows the note, or some vice versa. So me understand is you need to have that full chain of assignments if it's secured in order to sue on the note in Georgia.
You don't have to have the assignments.
Okay.
The allonges, yes.
Okay,
the
perfect.
Assignments,
Okay,
the
good.
assignments you
All right,
do.
good.
Because the assignments apply to the security deed, and that's only the only thing the security deed is doing is giving you that right to foreclose through the power of sale in the non-judicial process.
Awesome. Because what we started to do is we took down some trades, and of course, collateral is the biggest thing in this space, and sometimes you have to wait for those assignments, and you want to move forward and start some type of action to start the negotiation. So we started to use the strategy of suing on the note, and you have some attorneys say, well, you don't have all the assignments, you don't have it all. Like, well, what if it's foreclosed and there's no assignment and it's just a note? Well, then you can sue, or you can't now. So that's great that we got clarity now that you can actually still do a legal process if your collateral is not intact as far as the assignment chain, and you can sue on the note. And,
absolutely. It's nice to have. When you sue, especially in Florida as a judicial state, when you're filing a complaint, when you're alleging all your allegations, you'd love to have it all laid out and have everything attached to the complaint. Your note, your allonges, full chain of title on the note, then your mortgage, then your assignments of mortgage, so you can show full transfer of both the note and the mortgage. It's great to have that. Can we do it without it? Absolutely.
That's awesome.
With the note and just the mortgage, and showing that the note's been transferred, absolutely we can go forward on it. By having all your documents, you're just knocking out legs of defense counsel's arguments later on. So it's nice to have it at the beginning, but we can go forward without it as well. So.
Good stuff. So what would you say in closing? What would you say as far as people who are new getting into the business? Some of the things to look out for, whether they're in Georgia, and then I'll let you talk about Florida. As bringing a file to you, what are some of your expectations to make sure that you set them up right, for success to be able to recover on that asset?
First of all, it's just making sure you do your due diligence and you have all of your documents prepared, ready to go. When I have a new client come in, I actually have like a checklist of documents that I require, and that if they send those to me, I'll be able to hit the ground running. I'll be able to start very fast, get everything done quickly, get that file set up. The quicker I can do that, the quicker I can generate demand letters, notice of sale, publication. So having all your ducks in a row before you call me would be really helpful. That especially is true, on an ongoing basis. You already have my checklist of the things that I need. So now going forward, this is everything for future referrals too, that you're going to be sending me, and then it turns into a process.
Awesome. What about you?
Yeah, same as what Brian said, but I think it's just having as much information as possible, knowing that you have the borrower's social security numbers, dates of birth. You have a good understanding of what the actual property value is. So if you're in a second position, that you're not running into the risk of possibly being stripped in a bankruptcy. Knowing if there's previous bankruptcy, knowing if there's previous foreclosures against a particular borrower, all the information you can provide to us, it just helps us. So We always tell our clients, we like to have open communication.
That's awesome. Once you did mention something about bankruptcy, I remember a few years ago, District, I believe it was 11, Georgia, Florida, and Alabama was stripping in Chapter 7. I want to say that ended 2016, June. It was a new ruling that came out. Those cases that happened back then, I see some buyers are buying assets that have Chapter 7. The lien was stripped back then, and they're buying the assets now, so they don't know. That could be possibly one of those loans that was in that area where it's stripped. Are they able to reverse that, or is that done? It's already stripped. It's already done. When that new ruling, did they go back and can someone, or is this a closed case already?
That I don't know on. I don't know if that had retroactive application, but I'm assuming probably not.
Okay.
I think that it was a Supreme Court case, and I think that the Supreme Court would have had, and I have to go back and look at it, but I think they would have had to say in their order that it was retroactive, and I don't think that they did.
Yeah, I would assume that they probably whatever protection they got.
Yeah, I know it was a big celebration. I know when that ruling came out.
Yeah.
It was like Chapter 13, we know, and now Chapter 7. Oh my God! So bankruptcy is actually something good because you can actually go in and see what's going on. They signed the affidavit, they presented all their financials, so those have been good assets to kind of look at and kind of work stuff out with the bankruptcy. So I actually like when the bar file bankruptcy, except when there's no equity and they go to strip. But there's still opportunities there. But I definitely thank you guys for coming to the podcast and sharing your knowledge, and we'll get you on a social media page and kind of help generate some business for yourself and add value to the community by answer some legal questions. I'm seeing a lot of people who are not attorneys answering legal questions. So it's like, that was the main purpose of setting this up. So I definitely thank you guys for coming. So Brian Goldberg, Sean Mills,
Absolutely.
for Kelly and Sorohan. All right, guys, another great session. PFREI, your host, Fupan Bilal.